visa is one of the most popular work visas in the United States, and it's also one of the most difficult to obtain because of the shortage of visa numbers. In this video, I'll explain the H-1B visa, I'll discuss the shortage of visas, and most importantly, I'll discuss solutions to the H-1B lottery crisis. The H-1B visa allows U.S. employers to hire foreign nationals in specialty occupations that require at least a bachelor's degree or above. The typical applicant is a recent graduate who has worked temporarily pursuant to optional practical training granted at the end of his or her degree program. The most common H-1B occupations are in computers and high technology. These workers are in short supply and desperately needed by U.S. businesses. Unfortunately, there are only 65,000 H-1B visas available each year. Last year, U.S. Citizenship and Immigration Services, or USCIS, received 233,000 applications. In the years prior, they received 172,500 visa applications, and prior to that, 124,000 applications. USCIS's solution was to conduct a lottery and reject the extra applications. This leaves U.S. businesses scrambling to obtain H-1Bs for their workers and then having to come up with alternative solutions when they're unsuccessful. Applications for H-1B visas are accepted on April 1st of each year. So if you're thinking of obtaining an H-1B visa, you should begin the application process several months in advance. Typically, USCIS accepts applications for about a week and then tallies them for the lottery process. While it's not possible to increase your chances of selection in the H-1B lottery, understanding the logistics and requirements of filing can help prevent expensive and detrimental consequences. First, the application must be filed timely and properly. You must know the rules of filing. For example, you cannot file 2 applications or you'll be disqualified. You must file within the short filing window. You must precisely meet USCIS's filing requirements or the entire application will be rejected. Errors are almost never excused. You must also make sure the application satisfies the legal requirements of the H-1B visa. In both regards, it's important to consult with experienced immigration counsel who can make sure legal requirements are met and who has the resources to keep track of USCIS's many requirements. In addition to ensuring the best posturing for filing, immigration counsel can also help determine whether any of the H-1B cap exemptions apply. There are specific types of organizations that are cap exempt, such as institutes of higher education and nonprofit research organizations, etc. Private employers may petition under this provision if the employee will physically work at the cap exempt organization and there's a nexus between the work performed and the normal purpose of the nonprofit. If an employee is already employed by a cap exempt organization, any concurrent employment by a cap subject organization will not be counted towards the cap. 20,000 visas of the overall cap are set aside for individuals who have earned a U.S. master's degree, thus giving those individuals a higher chance of being selected in the H-1B lottery. Individuals who have been counted in the cap within the past 6 years and apply for an H-1B with a new employer are not subject to the cap. Individuals who are citizens of Singapore, Chile, and Australia qualify for visas which are not part of the H-1B cap. Because H-1B numbers are so scarce, employers must consider all possible options. In many cases, employers file over a year in advance just so they can have 2 shots at the H-1B lottery. Sometimes, employees may be eligible for other types of work visas. Analyzing these possibilities requires some work, but it's well worth it. For example, if an employee is a managerial employee or an employee with specialized knowledge and worked in a foreign branch of the company, he or she may be eligible to obtain an L1 intercompany transferee visa. If the company qualifies as having a foreign investment with a common nationality as the employee, then you may be able to obtain an E visa. If a position primarily involves training, then a J1 or H3 visa may be used. There are as many visas as there are letters of the alphabet, so only a detailed conversation about the specifics of your situation might reveal what other options you have. At McLane Middleton, we understand the fact that one of the most important resources of a business is having the right employees. We also understand that employers don't want to muddle their way through the complex immigration process to keep or hire employees. That's why we've created a simple and efficient procedure to help our business clients. We will work with you to make sure you've selected the best visa option. If it's the H-1B, we'll ask you and your potential employee to complete a short list of questions and provide us with necessary documents. From there, we're able to begin preparing your H-1B application. We make the process seamless and quick while accurately setting your expectations and thereby reducing stress. We compile H-1B applications and ready them for filing well in advance of the deadline. We FedEx our applications out on March 31st, priority overnight, with an anticipated delivery date to USCIS of April 1st. After it has closed the filing period, CIS logs in all properly filed applications and rejects any applications with filing defects. A computer lottery is then conducted to select the lucky winners. Those applications that are not selected are simply returned to applicants. For those that are selected, a receipt notice is issued. In the last few years, CIS has managed to complete these steps within about a month of the filing date. CIS then processes all cases filed via premium processing within 15 days and takes a number of additional months to complete the processing of remaining cases. Although an approved H-1B usually allows employment to begin on October 1st, there is a provision for students who are working on optional practical training to remain and work in the U.S. through the gap period. The H-1B filing fees must be paid by the employer. They consist of a $320 application filing fee, a $500 fraud prevention fee, a $750 or $1,500 enforcement fee, and an optional $1,225 premium processing fee that can be paid by either the employer or the employee. McLane Middleton makes the H-1B procedure as simple as possible for employers. We not only work with companies and their employees to gather the documents necessary for the visa application, we also work to strengthen the application and optimize the chances of success. If your application is not selected in the lottery, all is not lost. Our attorneys are skilled at determining whether alternate visa possibilities exist. Each visa is specific to a particular set of circumstances, and careful analysis is required to determine whether a possibility exists. If you have any questions or need additional information, please do not hesitate to contact me.